Hello everybody, I'm Sabine Yapane from Holmes Institute. Today I'm presenting on the business law, trimester 2nd 2017. I'm going to present about the case of Roger and Whitaker which took place in 1992. We are the group number 47 and my group members are as follows: Sabine Yapane, EMB 21473, Anumananda, EMB 21597, Rajesh Karki, EMV 20055, Ramila Sunwa, EMV 22060, and Deepak Tamang, EIN 2023. So the introduction of the Roger and Whitaker will be explained by Anu in further details.
Hello everyone. As Sabine mentioned about the Roger and Whitaker case, I'm going to talk about the introduction section. Mrs. Whitaker, the respondent, has been nearly blind in her right eye since age 9. In 1983, at age 47, after a routine eye checkup, she was referred to the appellant for the possible surgery. The defendant, Dr. Roger, advised her that she could operate on her right eye to remove scar tissue, to improve its appearance and possibly restore significant sight to that eye, as well as assisting in the prevention of glaucoma. Following the operation, Dr. Roger, there was no improvement in her eye even, and developed inflammation and sympathetic ophthalmia in left eye, which led to complete loss of sight in the left eye and thus almost total blindness. The defendant had not advised the respondent of this risk to Mrs. Whitaker. She sued Roger in the Supreme Court of New South Wales for damage of negligence. That he failed to warn Whitaker that as a result of the surgery she might develop a condition known as sympathetic ophthalmia in her left eye. Thank you. Hi again. Now I'm going to discuss about the fact of the case. As it was May 22nd, 1984, as discussed earlier, where the plaintiff, Mrs. Whitaker, was examined by the defendant, Dr. Roger, for the first time, and on the second consultation, almost 3 weeks later, Mrs. Whitaker agreed to submit to the surgery, where the surgical procedure was carried out on 1st August 1984. Soon after the operation, the plaintiff found no respite in her right eye and there was no improvement on her sight as well. Defendant Dr. Roger failed to warn her of the consequences and risks that may occur after the surgery, which was now quite evident after the surgery had already taken place. This was considered as the important case in the High Court of Australia, categorizing it for negligence of breach of duty by a medical practitioner, wherein he did not carry out this duty to warn a possibility of adverse effect of the proposed treatment to her client. As a result, the plaintiff had become blind on her good eye as well, giving the risk a much bigger importance than it would otherwise have been. Thank you. And the judgment of the court will be discussed by Deepak Tamang.
Now I'm going to speak about the judgment of the court. And the respective panel of the judges of this case were Mason, CJ, Renan, Johnson, Chuhi, McHawk, who commented on this breach of duty and coercion. And they mentioned that plaintiff should have been informed about the consequences and the danger of the sympathetic ophthalmia, and she was asking the same of her doctor. In this case, though the plaintiff has not asked the correct question, but she expressed her concern clearly and directly to the doctor that nothing should happen to her left eye, which was her only hope of seeing the world. And the trial judge disagreed with the defendant on the fact that since Mr. Whitaker did not frame her questions regarding harm to the good eye correctly, that does not give liberty to the doctor to hide things from the patient and not make her aware of her risks associated with the surgery to her good eye. It was also noticed that on this basis, even the counsel fighting the case on behalf of the defendant did not put into any further appeal and also did not make any submission in this regard. Therefore, there was no grounds left for the defendant and their counsel to fight upon the case. The judges ultimately dismissed the case with cost being incurred on the defendant. Thank you. And the further case gonna explained by my friend Rajesh. Thank you.
Thank you, Deepak. Now I'm going to explain about the issue raised by plaintiff and defendant. From the plaintiff side, I'm going to explain that Miss Whitaker has expressed her interest that she doesn't want her eye to get harmed as a result of the eye surgery. On the other hand, as a defendant, Dr. Roger suggested and prescribed her a pair of reading glasses, but she doesn't want. He referred Miss Whitaker for the suggestion for the possible surgery on the right eye as well. And on the plaintiff side, she boosted up the fact that the doctor has failed to warn her of any risks and adverse, and it was against the duty of care. Against the duty of care, and it's due to the negligence. And at the defendant side, I want to explain further. He further claimed that the risks of sympathetic ophthalmia was considered as a one among 14,000 cases, and therefore such information was to be mentioned to the patient. And as I further explained from the plaintiff side, she provided evidence at the court trial that is condition of losing her eyesight was slightly greater when the surgery is being done to the eyes, which already has pretending injury on the same eye is being operated again. And as a defendant, the defendant also claimed that the eye surgery was elective for the Miss Whitaker, and therefore she had option of avoiding the same, as there was no medical urgency of conducting such a surgery. At last, I'm gonna as a defendant, he didn't have a proper evidence to prove himself that he is right. So further, my friend Sabin gonna explain as a conclusion.
Hello everyone, thanks for this. As per the conclusion of this case, that plaintiff also suggested the practitioner to place a patch over her left eye before the surgery. This shows that she was highly concerned about her good eye as well, but the defendant completely ignored that at the moment. And defendant must have warned the plaintiff about the consequences that can be faced due to the surgery, but he failed to do so at the current instant. This gives right to negligence on the part of the medical practitioner and owes duty of care to the plaintiff. Therefore, the liability on the part of defendant arises, and the damages to be paid to the plaintiff. Thank you.